Appeals of Tennessee is now in session.
Thank you, Mr. Hevner, and on behalf of Judge McBrayer and Judge McGee, we welcome counsel to this oral argument, which we are live streaming in order to fulfill our obligation to maintain open courts. We will conduct the hearing in the same manner as if we were all together in the courtroom. Each side has 15 minutes to argue, and the appellant has reserved some of that for rebuttal. There being no announcements, I'm Mr. Hevner to call the case.
Christina Compher versus Dana Janelle Whitfield.
All right, Ms. Rubenfeld.
Good afternoon, Judge Clement and panel. I'm Abby Rubenfeld of the Nashville Bar. I represent Christina Compher, and my co-counsel is Laura Rogers of the Memphis Bar. I'll be arguing the case, although I guess Laura could jump in if I say something terribly wrong. This is a parentage case. It's based primarily on a statute, on a provision of one part of the Tennessee parentage statutory scheme, TCA 36-2-304, subpart A4. The holding out, that's I call colloquially the holding out provision of the parentage statute. This particular section of the parentage statute only is for unmarried people. This is not a statute that helps establish parentage for someone who's married. It's only for unmarried people like my client, Ms. Compher. It's also not a statute that's related to biology alone, as was incorrectly stated in the Pippin decision. In fact, the particular provision that we rely on, the holding out provision, doesn't require biology, marriage, adoption, nothing. It simply requires specific conduct by a person. And in the language of the statute, it says a man. But our position, the whole issue in this case, is that there is no reason, no valid constitutionally sufficient reason to limit the interpretation of that statute only to men. What we're talking about is not the means by which a child was conceived, which of course can matter what a person's biology is. That's irrelevant to this case. This case is about behavior, about someone who takes a child who is not related to them biologically, not related to them by marriage, not related to them by adoption, takes them into their home, holds them out to the world as if it was their child. And the natural part is completely irrelevant here. The statute says if the person holds the child out as their natural child. It's about behavior, not about the person saying, yes, I gave birth to the child. That's irrelevant. This is about people who do what my client did, who act as a parent to a child for years and years without a biological connection, without marriage, and without adoption. And this statute protects that child's relationship to that other person that they regard as a parent and that their biological or legal parent taught them was their parent. This is not going to open the floodgates to every babysitter or waitress or teacher or whatever seeking parentage. This is based on a specific provision of a child, bringing a child into your home to live with you and holding that child out, telling the world that that child is the same as if you gave birth to that child. The means by which the child was conceived, whether it's artificial insemination, embryo transfer, old-fashioned, plain old heterosexual intercourse, the means of conception are irrelevant. What matters for this particular provision is how the child, is what the parent did, what the person did in holding out the child as their own. There's also
is the fact that there's a definition section with the parentage statute, does that make any difference here, or should it?
Well, that's I think a problematic part, but I think the Tennessee courts, beginning with our Supreme Court in 2005 and going right up to the decision in the Potts case last year, our courts have recognized that the statutory parentage scheme has not kept up with technological developments or really changes in the American or the Tennessee family. So the definition section is problematic. There's also a problem with the definition section because it's inconsistent with the language of the provision at issue. So we have two statutes that have inconsistent use of words, because under this statute, it doesn't, the statutory definition where it has the biological parent, biological mother, those kinds of words would rule out, it's inconsistent with the language of 4, which doesn't require biology or any of those things. And it's well established that when there's different meanings that can be given to statutes, it's a well-established rule of statutory construction that courts need to go with the reading, the interpretation that will maintain the constitutionality of the statute. And here, that's simple and to me, obvious, because it's we're not talking about the whole parentage scheme. We're talking about one section that says, while the child is under the age of majority, the man receives the child into the man's home and openly holds the child out as the man's natural child. What if Christina Compher had male genitalia, was a man, then what she did, she would have standing. But simply because she's female, the courts have held she does not, which is inconsistent and violates our statute 1-3-104 that requires a gender neutral interpretation unless a different definition is manifest, and it's not here. The behavior that a person engages in to hold out a child as their own is exactly the same if they're a man or a woman. It doesn't matter.
So the statute here creates a rebuttable presumption, and under the subsection that you're writing under here, how would, I mean, in a heterosexual relationship, the mother would say, okay, father, take a DNA test and I'll exclude you as a biological father. And that's how I'll rebut the presumption. How, in a general neutral way, would you ever be able to rebut the presumption created by the statute?
Well, in this particular case, we're talking about two women, and there's not a biological father involved. There was donated sperm.
Right. So in this case, how would Ms. Whitfield then be able to rebut the presumption here, assuming that this subsection applied to your client, Ms. Compher? How would Ms. Whitfield ever be able to rebut the presumption?
I don't think that the rebutting the presumption is not a right that Ms. Whitfield has. The rebuttable presumption is for the person claiming, the other person claiming to be a parent. And in this particular case, what we're asking for from this court is to send us back for a trial so that we can prove that we fit within the statute. And the proof is the facts in this case that have to be taken as true for purposes of this appeal are that Ms. Whitfield, along with Ms. Compher, held out Ms. Compher as the other parent, that she made this decision to have the child together with Ms. Compher. They decided together, they did the insemination, they did everything together in raising this child. And the proof, if we have a trial, will establish that. So the person that might try to rebut the presumptions, not Ms. Whitfield, if her argument is trying to leave a child with one parent alone. Prior to her breaking up with Ms. Compher, this child had two parents. The facts of this case are undisputed. My client supported the whole family. She claimed all of them, Ms. Whitfield, Ms. Whitfield's two children from a prior relationship, and this child they had together. She claimed them all on her taxes as dependents. She named them all as beneficiaries on her life insurance. She was listed as this child's parent with agreement by Ms. Whitfield at the child's school. The school accepted her money to pay for this child to go to school, even after the adults split up. So it's not Ms. Whitfield's right to try to rebut that. It would be for the person claiming to be the other parent to rebut it. And in a situation with a man, I guess somebody could come forward and say they were biologically the other parent, and that would create a different issue for the courts to resolve. But it's not Ms. Whitfield's, right to try to challenge this in terms of rebutting the presumption.
Let me ask you one question about the factual allegations, the complaint that we
Sure.
have to take as true. One of the allegations is about the domestic partnership, and this relationship was formed in Maryland. Is there a domestic partnership, or at the time, was there a domestic partnership law in Maryland that we need to concern ourselves with?
I honestly, Your Honor, I don't know exactly, but given the timing that these women were together for more than a decade, I think almost 2 decades, I don't think back that far any states had those kind of statutes. But more significantly to me is that the right to marry, which I spent a number of years working on achieving at the US Supreme Court, the right to marry or the right to be in a domestic partnership is just that, a right. It's not a requirement. Simply because we're allowed, same-sex couples are allowed to marry now, or 20, 30 years ago, we could register for a domestic partnership. That was a great option. But just like heterosexuals, you're not required to get married, which is why we have statutes like this to protect children who are born into these unmarried relationships and don't automatically have the protections of our laws. I think it's really important not to lose sight of the fact that there's a child involved here. And the facts that are alleged are also that this child has been and will be harmed by this. As a parent, as the biological parent, Miss Whitfield helped teach this child that Miss Compher was her other parent. She taught her to call her a derivative of mama. She listed her as a parent. She did all that. So the child thought, this is my other mom. And then when Miss Whitfield was upset with Miss Compher and the adults split up, it's harmful to a child to then just say, yeah, yesterday she was your parent, but today she's not. I'm sorry that you love her and you're close to her. Too bad. And that's what happened in this case. That's what we want to develop as proof at a trial, that it's plainly in the best interest of this little girl to continue with the two people she learned and trusted were her parents. And then all of a sudden one is gone with we don't know what explanation, if any, was given to her.
Thank you, Ms. Rubenfeld. Your preliminary time is up, but we'll hear from you further on rebuttal. Ms. Smith.
Time flies when you're having fun, I guess.
Yes, ma'am. Ms. Smith for the appellee.
Thank you, Your Honors. Obviously, we are asking the court to uphold the trial court ruling and to affirm it in all respects, except as regards to attorney's fees. The attorney's fees had been originally granted at the magistrate level and then denied at the trial court level. It's our position that in this instance, it is very clear that Ms. Compher does not satisfy the statutory and legal requirements for parentage and does not have standing to be filing this suit. I've heard a lot about how there's an argument that we are just fear mongering with some sort of slippery slope. This case is the slippery slope. I do want to make a correction. Obviously, we are proceeding as if everything in the petition that is alleged is true, but there is nothing in the petition regarding these parties breaking up or that they were in a romantic relationship. I know Ms. Compher doesn't believe that that is important. I think when you are proceeding that this person was somehow denied rights based on her gender because of Oberfeld previously not being in place and that something has changed since then, these parties were never together in a romantic relationship. What was alleged was a personal relationship and domestic partnership. That is what happened. This is not a situation where two persons were prevented from legally marrying because of the current state of the law at the time, and that has now changed since Oberfeld came into place. It's our position that 36-3044 is very clear on its face. It addresses within the parentage statute a requirement that a child be held out by a man as a natural child. The term natural is there for a reason. Under Ms. Compher's argument that you're holding this child out as if it was a legal child or as if you were a legal parent. That's not what the statutory provision says. This statutory provision uses the word natural. Natural has a common meaning. It relates to a biological child. It is used in different definitions, but sometimes to make a comparison between a child that was born out of wedlock or to a married couple, or a child that was a biological child versus an adopted child. Natural child has meaning. I think it's important that Ms. Compher never alleged that specifically in her petition, but this particular provision, it is not discriminatory to read it as not being sex neutral. And I think that's something that is getting a little confused. We've recently had, in addition to Pippin, the POTS matter that came out and dealt with the artificial insemination and in vitro statute, not the artificial insemination statute. And we have similar issues as well, where I believe it's 36.1.102.36 that defines a legal parent. Legal parent, that part, it uses the words husband and wife, for example. That can be construed gender neutral, but to choose the word man and woman as in the parentage statutes does imply a biological component, we would argue. And it is our position that the requirement that this child be held out as a natural child requires that biological element. If this is not the POTS case, where in that instance, the in vitro fertilization statute was involved and a contractual legal right was created under that statute by the legislature that gave rights to both of the parties in that case. This child was conceived through artificial insemination. That statute does require the element of marriage. To remove that would be to ignore, again, specific wording in the legislation, which required that marital element. Yes, families are changing, and what defines parentage is new, but this is a situation where a third party is requesting a legal constitutional right to a child, a right that exceeds the right of a step parent, the right that exceeds the right of a biological grandparent. They're asking to have a constitutional right to this child. To do so without a very clear intention to enter into that contract does create a slippery slope.
What about the argument about domestic partnership?
So we have to take that allegation as true. Their statement is that they entered into a domestic partnership. There's no allegation contained in the petition that it was a sworn, verified, and signed domestic partnership like we have seen in other cases, such as in the Pippin case. But a domestic partnership, by definition, does not, it could be as little as two persons living together and combining money for purposes of buying a home.
But they can be broader than that too, though.
It can be broader than that, yes.
And here we just don't know because we're just running off the allegations of the complaint.
Correct. However, just the entry of a domestic partnership does not create a legal right for the second party in that domestic partnership to establish parentage of a child. If we hear a lot of discussion about this needing to be gender neutral. If Ms. Compher was a biological male who had entered into a domestic partnership with Ms. Whitfield, he would not have standing to file a lawsuit either. Without the element of marriage, he would not fall under the step parent visitation statute, and he would not have standing to pursue parentage of Ms. Whitfield's child. And Your Honor, I would like to go back a little bit regarding how would Ms. Whitfield rebut this. That's one of the issues where when they are proceeded under natural child, the most obvious means of rebuttal is to provide a DNA test. That is the most common way to rebut parentage in a paternity action. Here, I think no one is disputing that Ms. Compher does not have a biological tie to this child. There's also no allegation that she has a legal contractual right to this child through any of the statutory provisions. She's not a step parent. She's not a grandparent. This child was not conceived through in vitro fertilization, and the parties were not married. So they do not fall under the artificial insemination statute. Here, though, again, it's slightly different than Pippin. If we take everything that Ms. Compher says is true, and especially in light of Potts, there is nothing stopping these two women, if it was their intent, to go out to the courthouse, to wherever they want, and to get legally married, which then would change this whole argument. But they didn't do that. These are two non-related by contract, by marriage, by blood, by statute, women, one of whom had a child through artificial insemination and one of whom didn't. And this could have been, if this was the same situation as in Pippin, the issue could have been remedied, if you would, by them getting married, but they didn't get married because they were never in a romantic relationship. They were just as alleged in a personal relationship. And I don't want to get into that too much because I don't want to accidentally go outside the scope of the petition. But again, our provision is this court addressed this matter very clearly in Pippin. The court did a very comprehensive analysis in Pippin regarding the parentage statutes. The Pippin matter, in our opinion, clearly applies to the same facts. It's a child. The parties were not married. One parent has a legal right. She gave birth to this child. The other person petitioning does not fall under this statute. And we don't think that that was discriminatory in Pippin, and we don't feel like it was discriminatory here. And Your Honor, with regards to our request for attorney's fees, this is clear from the record. The Pippin decision came out while we were pending, and the ruling was under advisement from the magistrate. The Pippin opinion came out. It addressed the specific question that was being addressed in our motion to dismiss, is whether or not a woman can pursue a parentage action under 36-2-3044, which says that a man who openly holds the child out as a man's natural child was entitled to the rebuttable presumption of parentage. That is exactly the basis for this case here. Regardless of the fact that the Pippin case and opinion came out while that was pending, Ms. Compher still chose to appeal the matter to the trial judge, which was her right. And at that point, the trial judge found that it was not a frivolous action because Ms. Compher was trying to change the law. However, we would argue that that's incorrect. The ink on the Pippin opinion was barely dry at the time that they were trying to overturn it. I think Ms. Whitfield had a right to rely on that. And I think for Ms. Compher to continue to pursue this action, well, I think it is wonderful that she wants to change the law. It is not equitable or appropriate to force Ms. Whitfield to bear the cost of her doing so in order to protect her constitutional rights as a parent under Tennessee law. So we would argue that the trial court got that portion wrong when the trial judge elected not to grant attorney's fees for Ms. Whitfield having to file this motion to dismiss to defend her rights. And that's my argument, Your Honor, unless anyone has any additional questions.
Not hearing any questions from the panel. Thank you, Ms. Smith. We'll hear rebuttal from Ms. Rubenfeld.
Thank you, Your Honor. Let me just say real quickly about the attorney fee part that it's interesting to say it's not equitable to Ms. Whitfield, but Ms. Whitfield accepted Ms. Compher paying everything for this child for her entire life, for the first 7 years of her life, and then continuing to pay for school afterwards when she didn't want her to see the child because she was mad at her. So I don't think she should rely on equities in this situation. But let me get back to the substance of the statute. This issue of a romantic relationship is completely irrelevant. There is nothing in this statute, Section 4 of Part A of the statute at issue. There's nothing in there that requires a romantic relationship. A person who isn't romantically related but helps an abandoned child and fits the criteria of this statute is a parent. Romance is not involved. Plus, there is nothing in the record in this case to establish that these parties did not have a romantic relationship. Simply because that word wasn't used doesn't mean they didn't have one. It's our position that they did, and that will be established at a trial. It doesn't even make sense at all to think that a person would pay all this, do all this, if she was not considering this child to be her natural child too. It's frankly absurd. I mean, these people were a couple. They were in a romantic relationship. There's nothing in the record that says otherwise. It simply described it as personal and as a domestic partnership, which is a romantic relationship. But whether or not it's romantic, that's a red herring, that's a red flag, and it's not relevant if you read the language of the statute itself. And the issue about being a natural child, I think that counsel misunderstands the statute and misstates the facts in this case. This holding out provision, the whole point of it is that a person acts as if a child is their own biological or legal child. That's all that means in that situation, is that you hold the child out as if the child was your own. If the child was actually your own biological child, the section would be irrelevant. There's already provisions, provision 5 in that same statutory section is about genetic tests to establish parentage. And it's also wrong in the Pippin decision and in the argument by Ms. Whitfield. Gosh, I just had a senior moment, totally lost my train of thought. It's talking about biology.
While you're trying to catch your thought, why does not the Pippin decision control?
Well, for one thing, it's not reported, and the rules of the Supreme Court specifically say if it's not reported, that it's not controlling, it's persuasive. And I would argue that it's not really persuasive because, respectfully, there are significant errors in it. And once the Potts case was decided, there is a conflict between two different panels of the same middle district or middle section of this court. The Potts case, of course, is different because they were married, but the twins were conceived before they were married. And Judge Robinson of the Third Circuit Court here in Nashville, he based his decision, and it was a complicated procedural posture about trying to set aside the divorce because saying there wasn't standing. But Judge Robinson, in addition to using the embryo transfer statute, which is written in gender neutral terms because it was adopted in 2013 as opposed to the parentage statute, which is very old. But Judge Robinson specifically relied on both the embryo transfer statute, which is gender neutral, and on the specific provision we're relying on. And he found that it does apply in this situation, that the statutes have not kept up with, as the Supreme Court found in CKY, that the statutes don't keep up with the practical reality of life and with the intent of the legislature. In these parentage statutes, the intent is to protect children, to establish parents as the people who have been acting as their parents. And the record, the undisputed allegations of this case are clearly that Miss Compher acted as a parent with the approval and encouragement of Miss Whitfield and with his child understanding that she was a parent. That's what's relevant here, the intent. And this statute, just reading its words, it clearly applies. Like there's no basis, simply because people conceive children differently based on their biological gender is completely irrelevant. The issue here is after the child's here, whether a person holds that child out as if that child was their natural born child. If the child was their natural born child, they would simply have to do a genetic test and it would be done.
All right. Thank you, Ms. Rubenfeld and Ms. Smith, for your arguments in this very interesting and important case. We will take the matter under advisement. Mr. Hivner.
This honorable court is now in recess until 2 p.m.
Thank you.
Counsel, you are free to